When people separate, sometimes, try as they might, they just are not able to agree on how their assets should be divided or how their children should spend their time with each other. In which case they need to turn to professional legal help. The courts are under such a huge amount of pressure that sometimes you have to wait months and sometimes years to have a conclusion to your case. With arbitration, it offers a real direct alternative to court where things can be dealt with much more swiftly. You have an expert in that area of law. You can be absolutely guaranteed that they know their law. They will make the decision for you and it will be binding, and it's all over much, much quicker, and it will cost much less overall than very lengthy proceedings, which is what happens in court.
At 3PB, we have a team of highly qualified arbitrators who can achieve that for you. The decisions to be made for your family are probably some of the most important decisions that will be made. Only once the issues are resolved can you and your family move on with your lives.
You also will be holding the arbitration not in an impersonal court building, but in a meeting room of your choosing. The arbitration can be arranged at a time to suit you and the arbitrator and your lawyers, so you don't have to worry about adjournments. Going to an arbitrator rather than the court, you can guarantee that the person who is making a decision about your life is an expert, will have read all of the papers, will have had the time to do so, and will have the time to consider your case. They give you a written decision on all of the issues that you have asked them to decide.
The arbitrator can be asked to resolve a single issue that's been preventing you from reaching an agreement, such as where your child attends school, or the equity division of the sale of the family home, or the arbitrator can be asked to resolve a number of issues or all of the issues in your particular dispute in order to achieve finality in your case.
A particular feature of arbitration is that at the end of it, there is a definite decision, a definite outcome. And in that respect, it differs from other forms of non-court dispute resolution, such as mediation. If a person is dissatisfied with the outcome, they can apply to the family court for a different decision to be made. The court will apply the same principles as it would if there were to be an appeal from a decision of a judge sitting in court. That is, the person seeking to challenge the decision would have to show that there is a realistic prospect of success in securing a different outcome to that reached by the arbitrator. So it's sometimes thought that if people go to arbitration, that they might not achieve an outcome and that they might have wasted their money. That is simply not the case.
It's not necessary to do mediation and then arbitration. It is possible for you to do one and then the other, but it's completely up to you. If you go to mediation and you are able to agree on most issues, then you can send the other issue or issues to arbitration and somebody can make a decision for you.
The arbitration will involve one short directions hearing and one final arbitration hearing. It's a streamlined process so that it is not dragged out and costs do not spiral. The agreement to arbitrate binds both parties to the process and to the arbitrator's decision.
At the first discussions hearing, one of the points you might raise is concern about seeing your partner, even if you don't have to talk to them directly. Sometimes that can be a bit disconcerting. But there are ways in which you can have discussions to where you sit, how you sit, to try and get the best for everybody, really, because at the end of the day, we want you to be able to fully take part in the arbitration. From the perspective of where you sit in the room, that's entirely, again, a setup that the arbitrator can have the final say over. You can always negotiate. Negotiation is something that is open to everybody. And whether you're going through the arbitration process or not, that's something to keep considering. It's a decision made by an independent person, and that often can make it more helpful because at the end of the day, it's not the onus on one person through the parties, it's the independent arbitrator who's making those decisions. but you must speak up. If you've got concerns about where you are in the room, how you're able to present, it's important at the discussion at the first hearing to speak up and make your concerns known to others. The other thing to remember is there's a lot more flexibility than a courtroom layout, because we're using specific meeting rooms that can have designated areas set aside for people, and it's a lot more flexible, a lot more comfortable, and I'm sure in that respect you'll be able to feel as if you're getting full engagement yourself and for all the parties.
In terms of timescales, it depends, of course, upon the complexity of the arbitration. My own experience is of arbitrations that are resolved within 10 weeks of the initial case being referred to me, and that is not an unusual timescale. In financial cases, it may take longer because you may need expert reports, but it is far quicker than anything that would be experienced by applying to court. In a court, you certainly would not expect to have a final hearing in either a children case or indeed a financial case within a year if the case were to be contested.
You shouldn't worry about choosing the wrong arbitrator. Arbitrators are all experts in family law, and you have a choice of who you appoint as your arbitrator. If you're unable to choose between you, you can go to IFLA, who's the Institute of Family Law Arbitrators, and they will appoint somebody for you. So you don't have to worry about that.